that have come back to bite people. There's been a couple of high-profile cases that have been in the media recently about people who said things either in a previous life or a long time ago that have come back to bite them, as I say. So Grace is initially going to talk us through some of those examples, and then we're also going to have a look at the sort of the power of social media and the impact it can have on people, perhaps innocently putting something online and suddenly they're made famous or gone viral, as the expression goes. And we'll talk about through, and then we'll look at obviously the risks that transpires or that transpire for employers and the problems that can face. Michael's got some case law examples, and then finally we'll have a little look at what employers can do to mitigate those risks and avoid claims. Okay, so I'll just hand over to Grace, who's going to do an initial bit about some high-profile cases that you may have seen last year.
So hi, yes, good afternoon everyone. So obviously with social media, it's a brilliant tool. It can be used to connect with people. It can be great for businesses to kind of connect with the wider area. Obviously it does come with risks as you are sharing your lives on social media. So from the slide here, you might recognize some of the more viral things that happened with Zoom meetings last year. So on the left, we've got the infamous Jackie Weaver and her rather chaotic parish council meeting. So that was recorded just by the local, the parishioners, and didn't really expect it to go any further. And then, of course, it went viral. And then on the right, we've got the cat lawyer. So this was in America on a Zoom trial where they couldn't get off the cat filter. And so the cat is in fact a lawyer who had to insist to the judge that he was a solicitor and not in fact a cat. Obviously, none of the people involved with these kind of situations could ever have expected anyone kind of beyond the calls to see them, so they ended up being watched by millions of people around the world. And while these were both quite, light-hearted and quite funny situations, it could have gone the other way and maybe had quite disastrous consequences. For example, the people of Handforth Parish Council, if one of them was one of your employees, would you be concerned about the bad press that they could have generated? Or the opposite effect, Jackie Weaver's become a little bit of a local hero. Would that be great press if she worked for your company? So it's commonplace now to have a lot of social media presence. Most people have it, and you do share a lot of personal information on your social media. For example, Jackie Weaver might have a Twitter account, as she now does, and I know Michael follows her and loves it. But so if she might not mention that she works for Aaron and Partners on her Twitter, but it could be linked to a LinkedIn, and then suddenly there's a connection there. So today, we're going to be covering kind of how the use of social media can cause these kind of issues for employers without even realizing. So I will hand over to Michael so he can go through some of the examples.
Thank you. So we just, as Paul mentioned, we're going to sort of focus a little bit on historic tweets and the impact they can have. Some recent news stories. Ollie Robinson, cricketer who was, you may well be aware, was suspended. I think he's recently been reinstated. He's recently able to play again, but he was handed an 8-game ban following tweets he made and posts he made in 2012 when he was only 18. And I mean, I think, what I think Paul and I thought was interesting about that is obviously he was a young man. The tweets were clearly offensive. They were clearly things which were racist and Islamophobic. And he showed a lot of contrition and apologized profusely since then. Said he's embarrassed and ashamed about the tweets he posted. And to be honest, the regulatory body as well, the cricket regulatory body, the CDC, also said, that they recognized that he was contrite. And you sort of, in that circumstance, you sort of wonder why no one, he's the kind of person international sportsman would have had representation and support and agent. and obviously the teams that he plays for, why no one sort of helped him and picked up on those earlier tweets. And maybe it's one of those things that as people get older, I think they start to ideally go back over their history online as people are more online through their youth. Someone like Ollie could have been protected a bit better, perhaps, and perhaps persuaded to take those old posts down before they did any damage. But obviously, this is not so much an employment issue in this particular case, but it's one that you might want to bear in mind. And we're going to talk a little bit later on about a possible suggestion of the idea of an amnesty or kind of supporting your employees to review their online history. Sei Omuba, this was an employment tribunal case where she was an actress who was cast in the role of Sally in The Color Purple. She's a strong Christian, and another actor actually sort of outed her on the internet for some tweets she's posted, Facebook posts rather, she'd made several years before in 2014, which were homophobic or at least expressed, her religious views against homosexual activity, right? And she eventually was dismissed, and her agent also dropped her, and so she sued both the company and the theatre company and her agent. What actually came out of that in this particular one was that because of her Christian beliefs, she said she had no intention of playing that character as homosexual anyway, which rather meant that it was going to be a breach of contract in any event, which is why she's certainly the main reason that she lost her case. But she tried to sue Leicester's Curve Theatre. She'd been due to play this role, and as I say, there was a sort of breach of contract in that respect. But obviously, the tribunal also looked at her right as a Christian, her religious beliefs, to express those views. But when it came down to it, clearly the contract couldn't be fulfilled. She said she could play that role, not in a homosexual way, if you like, but the character has part of the play, if you know it at all, is that the character is unfortunately very abused by first her father and then her husband that she's forced to marry, and eventually finds sort of freedom in a lesbian relationship broadly. And so it made no sense for her to even have accepted that role. So that's something to consider as well. If maybe that's pretty theatre specific, but if it's something like a role that requires, you wouldn't want an LGBTQ plus champion in your workplace who had a religious view that conflicted with that. And so, it sparked quite a social media backlash. Now I'm going to talk a little bit about some of the cases that have arisen. So this, obviously, I've talked about Sei Omuba, which is a recent case, but I think it's quite fact specific. And as I say, it sort of revolved a lot around the contract breach itself, or the fact that she was going to breach the contract. So the first one here, we just picked out a few. There are so many, and I've picked out a few that just have some interesting points. I think one of the key takeaways, though, over all the cases, is that it is going to be a case by case basis on which these things are going to be decided. In the first case here, Game Retail and Laws, the Employment Appeal Tribunal actually sort of declined to give any guidance on social media cases and any kind of legal tests that might apply. So I think the general rule on a lot of this is going to be about investigating, using common sense, analyzing what the issue is in any particular circumstance. If you have an issue with an employee perhaps inappropriately using social media, for example. So that's what happened with Game Retail Limited and Laws. This went to the Employment Appeal Tribunal and then was referred back to the ET. Mr. Laws was working for the video game shop, and he was working in there. He was I don't know the title of his job, but he was sort of security, if you like. He was monitoring security. And what he actually did was he set up his own Twitter account, a personal Twitter account, to follow the game store's Twitter accounts and kind of keep an eye on what other employees were tweeting to kind of police them. Ironically, then he used that personal Twitter account, saying some reasonably sort of offensive or inappropriate things, albeit they weren't the worst I've seen in some of these cases. So he said things like, "This week I've been mainly driving to towns at the arse end of nowhere, shut roads, and I'm going to avoid expletives in this one, but and idiots, let's say, in caravans, road rage, and loads of fags smoked, things like that." So not overtly offensive to any particular individual or category of person, but not really appropriate when you factor in that he was very easily able to be linked to his employer. It was a private Twitter account, but the EAT actually looked at that and they said, look, it's not private, because he hadn't locked it as private, which you can do on Twitter, albeit it's quite limited, and so there was no kind of protection from that. And his followers, it was clear from all the people that followed him, that all the different game stores, the branches, and so on, and the other employees, that there was a clear link with his employment. So eventually he was dismissed, and the ET originally found his dismissal was unfair because it was a personal Twitter account, but the appeal tribunal overruled it. So I think that's one thing to consider, and that's one of the key things that I think comes up again and again. If people are posting, tweeting in a private capacity in their personal email address, with their personal Twitter account or their personal Facebook account, is it connected with the employment at all? Does it affect the employer? Why would the employer have a right, I suppose, to decide that employee can no longer work for them, or to discipline them? And so a lot of this is to do with applying a test of, what is the effect on the employer? Is there an effect on your reputation? Is there a reason that it can be obviously linked to the employment? Facebook cases also introduce the fact that there are privacy settings where only your friends can see your posts. But when it comes down to it, as we all know, they can be screenshotted, people can send things on. And so you don't, once things are out there, I think employees quite often forget, even in a private capacity, even when you're posting in a private capacity, it can get sent on elsewhere. British Waterways Board, a similar case in a way, an employee making derogatory comments, but he was specifically doing it about his employer. He was doing it on Facebook. He said things like, "That's why I hate my work." This is one of my favorites, actually. "It's not the work, it's the people who ruin it. Nasty, horrible human beings." And you can imagine the effect on his colleagues seeing that in Facebook posts. He also wrote a lot about being on standby and getting drunk, which is obviously inappropriate, again, a conduct issue. His dismissal was found to be fair by the Employment Appeal Tribunal. The interesting factor on this one is that he was making those comments over about a 2-year period, and the employer hadn't really done anything, the Waterways Board, and they only decided to actually take any action after some grievances were raised. The EAT held it didn't matter that the misconduct had taken place 2 years before dismissal, or that the employer had been aware of that misconduct throughout that period and not taken any action. Because they were still able to show it was inappropriate conduct, and they stopped him doing it, and he still did it. So it was a fair dismissal. Tegat, it's not a particularly important case, but I thought it was useful just to flag up some other issues that arise around these kinds of cases. It's an employee posting inappropriate comments, but this one, it was very specifically aimed at a female colleague, and he was posting on his Facebook page allegations about her promiscuity, suggesting she slept around and had slept with everyone at Teletech. His dismissal was also fair. However, it wasn't due to the employer's reputation. So it didn't really affect their reputation, according to the Employment Appeal Tribunal, but the employee's harassment of his colleague was in breach of their policies, of the employer's policies. So there's probably two things to consider if you find an employee is posting inappropriate things, whether those are old historic tweets or posts or something recent. And one is the effect on you, the employer, or not you, but the company. And the other is also to consider the effect on individual employees, especially if they're targeted as these were. The claimant in this one, in bringing the unfair dismissal case, also tried to argue that he had various human rights that were protected when he made these posts. He first of all, he tried to say they were private under Article 8, and it was an invasion of his privacy. But again, going back to sort of whether Facebook pages are private or not, the Employment Appeal Tribunal found that, the Employment Tribunal found that that it wasn't, that it's not sufficiently private to trigger that article, or it wasn't in this case. I suppose that may depend on the specific privacy settings that are on Facebook. He also tried to argue he had a freedom of belief under Article 9, which extended to the belief about a person's promiscuity, which I think got very short shrift from the judges. But also I think the right to freedom of expression, and obviously this is one that comes up again and again when people have internet spats. Freedom of expression, sure, but what the court felt was that it has to be exercised responsibly. It didn't entitle the employee to damages a colleague's reputation and cause her to suffer harassment. So those are some of the sort of human rights angles that might be considered in these cases as well. But as I say, the freedom of expression is balanced with the rights of employees and employers. Finally, the Forbes case, Forbes in London Heathrow. So this is an interesting one. This is one where it's the claimant bringing a harassment claim against the employer as being vicariously liable for the action of an employee posting offensive things. So the claimant was an airport security officer. One of his female colleagues shared an image of a gollywog. So he's a black security officer. They shared this golly on her Facebook page with a message saying, "Let's see how far he can travel before Facebook takes him off." This is an outdated symbol, obviously considered to be racist now, and that's something to consider as well, is that people's attitudes towards language and towards symbols changed radically over the years, I think. Personally, I think to the good on the whole, but it can cross a line into people doxing, which we're going to get to in a minute, or outrage on the internet about things that people do. But this was, I think this was clearly intended to be offensive. They were saying, let's see if it can get, how long it will last on Facebook. So the claimant who was offended by it complained to his line manager. There was a formal grievance, and the employee was disciplined but only given a warning. So the claimant brought a claim for harassment, and so it's a bit different from the dismissal cases I've just spoken about, in that this was defending a harassment case. In this case, the employer wasn't liable for harassment. The colleague had been at work when she posted the image. She hadn't been at work, and it didn't sufficiently connect with her employment. And of course, that is going to be the test in any vicarious liability action. Was the action taken in the course of employment? That's the essential element under employee liability under Section 109 of the Equality Act 2010. So in that case, actually, the employer successfully defended the claim, but obviously there's a risk there of anything where there's a connection between the employer of anyone who's offended by it, potentially bringing a claim against the employer as being vicariously liable. And I can give examples of where that's. There are examples where that's happened. I've got one. There's a case against B&Q Trasler. It's just an employment tribunal case, who was unsuccessful in bringing an unfair dismissal case. It was unreasonable for the employer to conclude his comments were a threat to the business, where he was just saying a place of work is beyond a joke, saying things like that. But he had his compensation reduced by 50% for contributory conduct, so that's also a factor. I think those are the cases we kind of wanted to address. And you know, the reason for going through those, I think, as much as anything, is to show there is a difference of how they're dealt with. Each one is dealt with on its facts, on a case-by-case basis. But some of the main things to clearly look out for are: is the tweeting or the post connected with the employer in any way? Is it coming back on you, on your reputation? Also, is it is it clearly offensive to one of your employees or colleagues? And also, you know, if that's the case, you know, can the employer potentially be vicariously liable if you don't take appropriate action to defend or you know to protect, sorry, rather your employees?
I think,
So,
Michael, one thing to take away from those cases there, particularly the latter one, is that an employer can actually find itself in an employment tribunal, having not dismissed anybody, not done anything wrong, not had an incident take place at work, not connected to it, and yet still find itself facing, you know, a grievance procedure and ultimately a tribunal. You know, Heathrow Airport wasn't involved in the posting of the picture. Suddenly it's now got to deal with a grievance about something that they had no control about, would never expected to have control over about. And then obviously then we've got a claim from the person who was offended by it. So it is, you know, an absolute minefield really, and there is, to a certain extent, you know, you can't really be completely protected from claims, because at the end of the day you have to trust people not to put these things out there online, and so often people do. And Grace, if you just want to click to the next slide.
So I think you're absolutely right, Paul, and I think, you know, we'll talk about some tips. Obviously, one of the key ones being have a proper social media policy and so on, but we'll talk about that in a minute. Grace, you were going to talk about, I think, was it Grace you were going to talk about this?
I'll pick up Paul. So doxing is kind of internet phenomenon which has grown significantly in the last few years as Twitter, particularly Twitter, but other platforms as well have grown and sort of impacted how we communicate with one another and how we decide to express ourselves. Effectively, what it is, and we've seen examples of this extremely recently. Obviously the England players who missed the penalties in the final. You know, immediately I saw tweets immediately after the game from like Black Lives Matter type campaigners saying this is going to be a problem, because they knew as soon as the three black players missed the penalties that they were going to be subjected to racist abuse online. And sure enough, by Monday morning, we'd seen fairly horrific posts directed at Rashford and the others because they missed the penalty. But doxing is where these individuals decide to put these posts on Twitter, and then other people on Twitter who take offense by those posts then decide to conduct basically a personal investigation, if that's what you want to call it, into their life online. So they will go back through all of their tweets to see if they can find about their life, where they work, who they might be in relationships with, where they live, and try, and then get all that information, and then they post it online, go to Twitter and say, go on Twitter, you go on and do your worst to these people. I've seen it myself firsthand, going to watch Liverpool, who scored a crucial goal in a game at Aston Villa. Someone an Aston Villa fan puts a tweet on about Hillsborough and Liverpool fans being victims of Hillsborough. Says something awful, and suddenly they've got the Liverpool supporters have managed to get hold of where this guy works, and are tweeting his company all the time saying, what are you going to do about this? What are you going to do about this? How is this acceptable? And suddenly, you know, I think this guy ran a plumbing business in the Midlands, and suddenly he's being bombarded, this business owner, online, because one of his employees has put something idiotic and offensive to Liverpool supporters, or to anybody, to be honest. But that and then suddenly, you know, the employer now is facing this problem. Well, how do I deal with this situation? Which, you know, I'm sitting at home at 5 o'clock on a Saturday afternoon, minding my own business, and suddenly I've got this massive employment problem because one of my idiot employees has gone and done this thing. So that's what doxing is, and obviously it's a consideration for employers is how do we deal with that once the situation arises. Grace, can you just click over to the next slide, please? Do my best, Chris, with you there. Doxing. So it's an example scenario is so an employee posts a controversial tweet which is sexist, and as that's now gone viral, how do you as an employer deal with that? How do you prevent it from damaging your brand, and what are your next steps? Well, it's very difficult, particularly, as that was an example there, that's Saturday afternoon. Probably not, the employee's probably not in work, and he won't be back in until Monday, but the internet doesn't wait, and suddenly you may find that you have to make a holding statement or put something out there. There was a couple of high profile ones on the England game as well. Guy worked for like planning surveyors and also an educational. A guy was a teacher, both put racist tweets or from their accounts. Posts were made rather, and suddenly these businesses have got to find a solution. So probably I think advise us some sort of holding statement saying we're just, yes, it doesn't look like it's acceptable, we are looking into it to find out exactly what's going on, because you don't want to jump the gun and find yourself you've done something irrational and then exposing yourself in terms of a tribunal claim. But certainly at the earliest opportunity, you would be looking at launching an investigation, potential suspension if you felt it was appropriate. But bear in mind, suspension isn't always appropriate. There must be a reason for the suspension. Check your contract, see if you've got a right to suspend. But if keeping the employee in work is not going to prejudice the investigation, then really is it necessary? And think about it too when suspending. But and then it is an investigation as to what went on. Get the employee in, discuss what they post, why they posted it. But don't forget that someone could have been sitting at home on their phone. There's all sorts of other explanations that may come to light, and so you shouldn't just assume that the person has sent it just because it's come from their account. But obviously on the back of that investigation, then you need to make a call. The biggest consideration, if you are worried about tribunal claims, is whether it was made in the course of employment, because that's really where the risks lie. If you're looking at dismissing somebody for something that wasn't connected to their employment, then you're probably on thin ice. So examining their profile, seeing whether it can be linked back to place of work, or even if they're, are they using their full name, and then can that name be then searched and go on LinkedIn, which is obviously a professional social media platform. But usually, I have to say, it's not too difficult to trace people back from social media accounts unless they are sort of consciously anonymous.
There's one thing I just wanted to jump in there, Paul, as well, is there's also, of course, people who do this doxing who maybe don't have particularly altruistic motives, and there may be occasions potentially, and there have been, where individuals have been doxed, where their employers have been hounded, get rid of this person, or what are you going to do about this, or whatever, and the employers have quite rightly stood by them. And so it may depend on what this particular post or incident is, but you may want to consider whether it actually is in line with your company values. Correct.
And I think there's a certain element of, again, Twitter is the obvious one, because that's the kind of place where it's kind of most opinions are shared, that people can take anyone can take exception with pretty much anything. So you find, people tend to have very strong views and can quite quickly find whether it's about something, what you're having for breakfast, or highly political sides of the fence that people might be on, and people can suddenly take exception to things. They might be on the other side of the world, and actually you might think, well, actually looking at it and doing investigation, actually I don't think this is quite as bad as it's been made out to be. But don't forget, you have got the eyes of the world focusing on you and how you're going to deal and react with it, because these people might be, begging for blood, mightn't they?
Yeah, exactly.
So, yeah.
Should we move on?
Go on, Mike.
I think we can move on, can't we? Grace, were you going to talk about this?
Yeah. So just kind of touching on things like doxing, obviously, as Paul was saying, you have to kind of consider the facts of the situation. So, for example, something that someone from a younger generation might not consider acceptable, from the older generation, they might not understand why it's not acceptable to say, and you do kind of have to consider those facts. So this is something that did cause a little bit of debate between the three of us when we were planning this. What generation we're considered to be and how we use social media differently. Although, there's not much of an age difference between all of us. There is some significant differences on how we use social media. So, for example, from my perspective, I kind of grew up with like the creation of things like Instagram and Snapchat as I was a teenager. Paul and Michael were well into their 20s at university using
30s. Yeah.
I just as at a point, I can remember being at university and someone saying, "Have you heard about Facebook?" And the thing being that you'd go on a night out as a student, and then in the morning there'd be 200 photographs on Facebook of everything that happened on the night out from the very start to the very end. So that, and they're just, they're put online without your consent, without your request. And suddenly they're all plastered all over the internet. Now that seems to be a bit of a dying trade with Instagram, but that's,
There can be quite a differing in attitude, can't there?
It's a different attitude, yeah, and it's changing all the time. But sorry, Grace, go on.
So like, the older generations, we were kind of considering, like say my grandparents kind of age, they might be more likely to fall victim to scams, and they might be more willing to post, controversial comments online, not really realizing the viral aspect of social media. Whereas, the awareness that maybe the younger generation have is due to the fact that we grew up with it. Equally, when you're young, so I was using Facebook and Twitter from when I was about 13. I'm sure if you dug back through there's stuff that I definitely wouldn't say now. And that's where we've got things like Ollie Robinson, that situation that happened with him. He was a teenager, and he wouldn't say those things now, but as a teen, you treat social media differently. And maybe this is where kind of a suggestion of considering all the facts, considering how it aligns with your company's views before you make a snap judgment of saying, I disagree, you're fired, etc., because that leads to all kind of problems. So we were going to cover a proactive suggestion. So shall I jump onto that?
Yeah.
I think one thing, that the kind of the main problem, I suppose, of social media is that it creates this fully documented account of your life if you're willing to put it on the internet. And once it's on the internet, it's in anybody's hands. And so again, if we use the Ollie Robinson scenario, but kind of if you imagine it was an employment scenario, well, that those tweets could have been made by, as I say, when he was a teenager, before he even got a job, and now you're the employer and you're potentially having to deal with problems from it that are created by somebody in a life well before you got to know them, well before the recruitment stage, and before you even knew their name, and you're expected to deal with an issue that's arisen out of the social media accounts, and potentially have liability as a result of that, and that is extremely tricky. And kind of, I think the longer, it's certainly not going anywhere. Social media, and in fact, it's probably going from strength to strength. We're seeing more and more use of new platforms. I've noticed a different kind of trend in how LinkedIn is being presented by young people now. We were talking about that yesterday, kind of more of a sort of personal presentation of themselves, what they look like, what they're hoping to achieve is being posted on LinkedIn more regularly, rather than when I sort of signed up for it and it was basically an online CV. And now it is giving it a more personal feel. And again, it's documenting people posting their university results and things like that. It's becoming more and more complex. And obviously we've got things like TikTok now, which are meant to be a bit more fun. But again, one 3-second, 10-second video or whatever you do on TikTok, I'm afraid I'm too old for that one. But it is, it could impact you know, a person's life and certainly their employment situation massively. I think we touched on yesterday, a couple of years ago, there was a solicitor who went on Love Island, and obviously that's a massive thing that social media is massive about, and she ended up having to leave a job prior to going into the villa, I think it's called, the villa, the island villa, whatever they go on. But that again, and you go, the practice in North Wales will have been concerned by the potential reputation that sort of someone presenting themselves on Love Island could have on their business. So yeah, just things to think about. So in terms of what we can do as employers, I mean, it's a problem. And you know, if you think of people like ITV, and every morning they must think, or must have thought, before she already dramatically walked off, what's Piers going to tweet today? That would be a real headache. I always used to think about the poor people who ran Donald Trump's kind of media campaign. I think, oh my God, what's he done now? And then having to kind of, you know, muddle through what he's decided to post off his phone before he goes to bed at night. Now that, you know, they're fairly extreme examples and two obviously very opinionated individuals. But you know, if you've got people who are kind of very proactive on social media in any way, not necessarily saying it's offensive, political, they might just present themselves in a way you think, is that how we want to associate ourselves with? You know, if that can be linked back to us as a business, then yeah, you know, there's things to think about. One thing, basically, we've had this idea, which has only come from sort of plotting around this, is whether you have an amnesty type arrangement where you could actually actively go to your staff and say, there's been some high profile things recently. You can use the examples we've given here today. And the obviously the Marcus Rashford abuse and things like that, and say, look, we've decided that we want to look at our own profiles. We're all doing it. We recommend that you go back to your Twitter, your Instagram, your Facebook, or whatever, and set and just do a clear up, basically. And if you think there's anything that's a bit dodgy or not appropriate, that might have been appropriate in 2010, but in 2021 is no longer appropriate, why don't you just delete it? And then you've got the opportunity to say, you know, it's July now, by Christmas, giving you plenty of time to go through, and when you should get around to it. And then in the event that something happens in, say, March next year, we've given you that opportunity to clear it up. And we've proactively managed that, and we've told you what's acceptable, we've told you what's not acceptable, and we've said to you, you know, if you're not sure about one, why don't you show us? But probably if you're not sure, that means it's probably not okay. So bearing in mind it was 10 years ago or 5 years ago, no one's really going to be looking at it now anyway. So why don't you just take it off? And then you've got much more scope in the event that something historical does come back to bite someone. And you can say, well, we gave you that chance. You should have deleted it. You didn't delete it. And now we're going to have to do a disciplinary because, we're now getting all this social media attention, or, you know, this is potentially racist, or this is potentially sexist. We've got to deal with this. So how is it best to, you know, we've therefore got to, you've had your chance and you haven't done it. I think the other thing is, if you've got new starters, now it's not uncommon that people will do a little Google around people's social media to check they're not employing a loony. But the reality is, if you say to them when they join, look, this is our policy on social media, we'd like you to go back over your own accounts and have a look and see what you think is appropriate, because in the event that something inappropriate arises, we'll have to deal with it, and we don't want to have to do that with you. So let's clear it up now, and then move forward together. And I think, you know, everyone can do that, can't they? You know, you can certainly say you can have the people at the top of the business and at the bottom of the business all sort of having a look at themselves and saying, well, I think it's probably time to tuck this off, even if it to avoid this. Obviously, employment lawyers love their policies, so having a clear social media policy, most of you probably got good policies, but, you know, could you draft something into that policy to say, it's, you know, we expect you to have a look back at historic tweets when you join, or just reminding people of what, because you can see, you know, there's some examples there where people have lost their jobs, and if you go to the people before, you know, we're all about preventative action rather than you know, having to resolve firefight type situations. I think that gives a lot more scope and protection, because if then they bring the claim and you've got, well, look, we gave you the chance and you still didn't delete it, and therefore we think, you know, what we did was right in terms of dismissing you. And I think that certainly helps, particularly with the historical ones. Now, if someone goes and puts something extremely offensive because England have missed a penalty, well, or Lewis Hamilton's crashed into, I think, Max Verstappen last week, and then their immediate reaction is, let's send them racist abuse. Well, I mean, that's clearly highly inappropriate and would be, in my view, a dismissal offence, provided it was connected to the employment. So I think, yeah, it's just steps that can be taken, but you know, I don't think you can just sit back and go, oh well, we found this tweet from 2009, we don't think it's appropriate, so we're going to sack you. Yeah. I think you'd be on thin ice, even if it was offensive. I think you would be on, even if it was a racist tweet, if it was homophobic. I still think, you know, if you're going back 10, 12 years, I don't think you'd be on the strongest of platforms to defend the claim if you just sort of went, oh, that's gross misconduct, but you're sacking you without these kind of layers of protection in place.
I think another thing to look out for as well, obviously, apart from offensive tweets and posts, we talked a bit about harassment, you know, potential risk of claims from other employees for being harassed but through social media by other employees. But also, there's also the risk of data breaches, of course, where employees will share personal data or sensitive personal data about their colleagues. And again, that's something that should be dealt with in a social media policy, should certainly be dealt with in a data retention policy. So again, that's just another factor in there. To a certain extent, I think that, you know, potentially that's more clear cut in terms of starting a disciplinary process and carrying out a disciplinary process. If there's a clear data breach, then, you know, you've got a pretty good reason to start a disciplinary and investigate that accordingly. But yeah, I suppose I just wanted to make sure that was a factor in this as well.
Yeah, absolutely. There's no doubt, but with the way we've all been working, or most of us have been working in the last, it used to be 12 months, what is it now, 15 months, since COVID hit, it's a new online, or it's more online than it ever was. Certainly, suddenly we were thrown into Teams and Zoom and doing presentations and team meetings in this way. That presents with it, you know, these types of things are recorded. Talked about the Jackie Weaver incident. There's also been several rather embarrassing moments for people. I think it was the chap on CNN who certainly didn't realise he was on the camera whilst he was actually on a recorded Zoom. And there's other examples where people are being recorded, and it's not really social media as a problem, but you know, just bear in mind that people are, you know, conscious of their obligations and what they should and shouldn't be doing whilst on Zoom. Team chat, or if you're using instant messaging, you know, constantly reminding staff that it's a work platform. It does become informal. People who tend to instant message things, and can quite easily, you can find yourself talking about people behind the back on a Teams or type chat, and that could actually be inappropriate.
Banter, don't you? I mean, that's the classic word.
The worst word in employment law.
Exactly. And of course, as is always the case with banter and chat, and you know, whether that's on Teams or chat, you know, on a messaging platform, or whether it's people chatting in the pub after work or in the office place, it's got the same issues of, you know, needing some caution as to exactly what people are saying, and even WhatsApp, managing those relationships.
WhatsApp is a social media platform, and if you know you're we've got an employment team WhatsApp group, but if I wanted to copy and paste the whole thread from now and since last March, it would take me 5 seconds, and I could bang it into an email. I think oh well, I'll keep that in case. And at time to time, people might send jokes or send things, and you think, well, taking out context in sitting in an employment trial and reading it out loud, it might not be quite as funny as it was at the time. Certain people may take offence. So to remind staff that WhatsApp groups are also work if that's what they're being used for. If you get a data subject access request, that could potentially be disclosable, as it could between two managers or whatever. So if it's a work chat, just remember those types of conversations. And if you're thinking of having conversations which you wouldn't want to be recorded, doing them verbally is certainly the best way. But again, even now, I've got a tribunal Thursday, Friday next week, and the claimant has produced a covert audio recording from an iPhone stuffed in his pocket, which he's trying to rely upon. So, always bear in mind when you've got your work hat on, and you need to be keeping it professional. And cyberbullying is another point. Like, it's not really social media focused, but it's something that you do tend to see, and that can tie into sort of mental health issues. But again, talking behind people's back on online chats tends to be the most common form of that in terms of this type of situation. Yeah.
So I think if we go to the next slide's the last slide, basically, isn't it? We sort of talked through a lot of this already, to be honest. Recruitment and training, support for employees. If they may be the subject of some abuse, policies and proactive management. Really, those are the things we've been talking through in terms of proactive steps you can take. I don't know that we need to cover that again, really.
It's one thing that we touched on at the end. I think if we go back to the first example, which I just think is such a good one, it's just the cricketer. Personally, I think someone should have realised 12, 18 months ago, this lad's going to play for England. Someone needs to, make sure he's protected from the, the day he makes his debut for England. He's not on the front page of tabloids because he's tweeted something stupid a long time ago, and he's on the back pages because he's, done a good innings or whatever. But that doesn't make it acceptable, and certainly it shouldn't be tolerated. But as employers, I think one thing to perhaps think about when you go away is, if that was an employment situation and he'd been sacked for that as a sort of 25, 24-year-old, starting out at the outset of the career for something that he did 5, 6, 7 years ago, is that really beneficial to the whole situation and improving our perception of things and how we interact with one another, and sort of, well, I suppose, make us a better person, or a better human being? I think is are you risking jeopardizing someone's whole future because of a stupid mistake they made a long time ago, and whether you would actually be better going to them and saying, look, this isn't appropriate, it's not appropriate now, we're going to have to deal with it, but actually we'd like to help you move forward, and actually use that person as an example to show to others that these are the policies we've helped you develop, and now you're an example for others in the future that it's you can make a mistake, but actually it doesn't necessarily need to sort of be the end of your career or whatever. And I think probably that would be a more long-term beneficial way of dealing with things, but each case is different, and certainly
I was going to say, just almost as a last point, I think that what a lot of the case law shows is that each case is different. It is going to be taken on its facts. So if you do have an incident, if you do have something that comes up, or whether that's because you've got an employee who's offended by a colleague's posts, or is being bullied or whatever, or if it's pressure from a third party from outside, like this doxing we talked about, it may well be something to take legal advice on early, rather than plowing ahead, unless you're very confident that the tweet is either not relevant, not related to the employment, or that it's that it's something that can be dealt with internally swiftly and correctly. I think that the problem is there is a minefield of you're balancing different, as I mentioned, human rights, as well as rights to privacy and things like that, as well as the normal kind of discrimination angles or harassment or dismissal and appropriate behavior. So it's a lot to factor in, and you can be a bit between a rock and a hard place in all of those cases.
Absolutely. Right.
I'd love to.
Any
see if we got anyone got any questions. If anyone's feeling brave and they want to unmute or put anything in the chat, or if Grace has got anything else to add. I think we covered a lot of it, haven't we?
I think we've done pretty well, really. Gone around all the houses.
So just before we came on the call, we discussed whether if social media could just be got rid of totally, and it wasn't a thing anymore, would that be for the best? And my view is that on the whole, it probably would be for the best. I think Michael agreed.
Maybe, yes, I suppose so.
I'm not sure what Grace thinks.
I wholeheartedly disagree. I think, as the young person that I am, no, you can use it for the good of the world. It does. There's so many benefits to it, even within business. So I think it's going to go from strength to strength.
I hope that we get, to be honest, I'm more in the middle there, somewhere between the two extremes. I hope that as a society we get better at dealing with these things and remember that we're all talking to human beings, and we're, and the same goes for, this is the thing in the employment context as well. Hopefully employees will remember that they are putting these views, often objectionable views, out into the world, and that it can impact on their employment and so on. We've got a question that I have to admit I can't think what it's referring to. What about the lost stolen dogs?
I'm guessing this is well, how would we ever find lost or stolen dogs if we didn't have social media?
Absolutely.
There you go.
That's a good point.
I don't know, did dogs not get lost or stolen before social media? Where do you get a
sign?
Stick it on
up. It's not quite the
same.
same.
On a lamppost, don't you? Where's Rex?
I'm not sure it's
Have
the
you
same.
seen Rex and the phone number?
Mind you, I signed up to this Nextdoor app recently, and it's just a nightmare. I get notifications constantly, and it's all inane and people being actually often quite offensive. So I uninstalled it pretty quickly. There you go.
Sorry, Paul.
But a lot of it is about finding cats and dogs.
Sorry, Paul and Michael, I had a question, and I'm sorry if you covered this. It's Ikram. Just wanted to quickly check, because there's been two examples, and you mentioned Ollie Robinson, and at the time when he sort of posted what he had posted, he wasn't an England cricketer. There's been a similar thing very recently that came to my attention on sort of LinkedIn, and the employer had taken a view. There was some posts about Hillsborough, but the employer then posted at the time where the person had made the comments, they aren't able to take any action because he wasn't employed by them. So you've got one example of where somebody wasn't an England cricketer, but England, the ECB decided to take some action. And you've got another view from an employer saying, well, it's something that was before that they were employed by us. So is there anything strictly from sort of in case law or anything that suggests that whether anything was done previously, can action still be taken against them, or does that actually prevent them from being able to take any action?
So the answer is it doesn't prevent you from taking any action as an employer if the posts were pre-employment. If it's affecting I think the main thing would be about affecting your business, and in fact you may be looking at, rather than a conduct dismissal, there are some cases that deal with some other substantial reason dismissals, SOSRs, where essentially it's about the impact it's having on the business. If you've got clients complaining or customers about this historic post, then it just becomes unfeasible to continue that employment relationship with that employee. But I think that's probably the extent of it, unless you can think of anything. I think
probably with the example that you gave, an England cricketer is high profile, and the ECB couldn't be seen to just say, well, it was a long time ago, not to do with us, because the public opinion would not accept that. Whereas with the other example, it's not, as I don't know the particular example you talk about. It's not connected to a protected characteristic, so it's not racism or a homophobic issue. And also, I think people with, very cautious to talk about Hillsborough, but people do have different opinions on it, I'll say. And I think that the employers, just as they probably just said there, look, it's not really anything to do with us, because yes, people may be unhappy with it, but it's well beyond our control. Whereas I think the ECB have had to say, well, actually, this guy is within our control, and we need him to sort of be held accountable to it, because, as I say, the public opinion will just not accept.
It has such an impact on the
that
world
being
stage.
pushed under the carpet. Yeah.
It just occurs to me there's one other thing that I hadn't, I don't think we slightly addressed, which is, I've completely lost my train of thought. I apologize. I was going to say something, and as finishing off that thought, I've lost what I was the train of thought for what I was going to say. Never mind. Can't have been that important.
Well, I'm sure you can do an email if everybody if you remember this afternoon.
Sorry about that.
It's worthwhile. Well, thank you very much for joining, everybody. If you feel like you've got any questions afterwards, or you'd like to have a one-to-one conversation, certainly just drop us a line. But thanks for attending, and I hope you found it helpful. And you'll probably see our post on LinkedIn after the event, so you'll like that if you like. But yeah, hopefully it was helpful, and we'll see you soon. Hopefully going to get these back in real life in the not too distant. So it'd be nice to finally meet those of you who've been loyally attending them online.
Absolutely. This is exactly the kind of session where we would love to be able to do it as more of a chat than a, exactly. We're telling you the law. It's intended to be that kind of session. So when it's back face to face, that will definitely work better.